Okay, well, I've chosen two topics to speak about. First, something about the revised court system that we have seen in Sweden, and also some increased in enforcement measures that the regulator can make use of. But also a quite interesting case about influencers, blogger, the first case about that in Sweden. It's a case pending, but it's still important since it illustrates how, among other things, how advertising disclosure is viewed upon by the regulator. But first, we have a new specialized court system, and that means that nearly all cases related to marketing, intellectual property, and competition are now dealt within the newly established patent and market courts. The first instance is the Patent and Market Court. Second instance is the Patent and Market Court of Appeal. And then in some cases, if there is a matter of precedence, you can also be allowed to appeal to the Supreme Court. And why this is important for marketing is that before, if you wanted to have a kind of a speedy case tried, you could abstain of claiming damages. If you did that, you would have first and final try in the market court, which obviously would mean that you secured that you would not end up fighting in up to 3 instances, as could be the case now. So this could probably mean that because there is no longer any real upside with not claiming damages, this means that we could probably look at more cases that includes damages. Another thing is that the Swedish Consumer Ombudsman can, since 1st October last year, impose immediate sanctions for breaches. Previously, that required the approval of the breaching advertiser or that the regulator went to court. So now they can decide about immediate sanctions, interim actions, without such approval. And obviously, that makes up for more rapid and efficient enforcement. Then we have the first blogger to be taken to court in Sweden for breach of marketing rules. It's a case where the Swedish regulator, the Swedish Consumer Ombudsman, has reacted and taken action against the advertising disclosure of a blogger. Previously, the Consumer Ombudsman has issued some guidelines on how to make advertising disclosures. That I would say is basically in line with what other authorities and guidelines in Europe says. Here's the blog post. There was no issue here that this was actually advertising. It was quite easy to establish. There was a post about a brand that recycles mobile phones. If you turned in your old mobile, you got a certain amount of money that you can spend on a new one. And the blogger here, she tried to do some advertising disclosure. She used the word or term sponsored post, and also in cooperation with, there were some links to the advertiser's company. The CEO was not too impressed with this. They made 3 claims. The most interesting one was that the post had not been formulated or presented in such a way that it is clear that they were matters of advertising. And what this case basically, the arguments basically means is that they thought that, the CEO thought that using the word sponsored post, that is not the correct way or term to use for advertising disclosure, because it's not about sponsorship or something. It's more of a direct, here where it was more of a direct marketing, and it's not a common term. So as the current status of the law is in Sweden now, I would say you should avoid using sponsored post or something like that when you want to disclose advertising. Also, the term in cooperation with the company, that was not even close according to the CEO. They denied that. So this is something that indicates how the regulator currently sees. It's going to be interesting to follow the matter and see what happens in the end. 5 seconds left.
Yeah.